Prince Harry's latest appearance in London's High Court delivered a moment few royal watchers truly expected, not because it was dramatic, explosive or emotional, but precisely because it was none of those things. In a sworn witness statement submitted as part of his ongoing legal action against Associated Newspapers Limited, the publisher of the Daily Mail and Mail on Sunday, the Duke of Sussex formally named his brother Prince William and his sister-in-law Princess Catherine. This was not a provocation. It was not an accusation. And it was certainly not a personal attack. Instead, it was a calm, restrained, carefully worded legal document, one that nonetheless carries enormous weight. Because for the first time in this long-running legal battle, Prince Harry placed the private dynamics of his closest family relationships into the official court record. Not for drama, not for revenge, but for context. And that distinction matters. This case exists within a much broader reckoning, one that goes far beyond royal intrigue or tabloid headlines. Prince Harry is one of several high-profile claimants accusing Associated Newspapers of unlawfully gathering private information over many years. He is not standing alone. The group of claimants includes musicians, actors, politicians and campaigners, people from vastly different walks of life who all allege similar patterns of misconduct. Among them are Elton John and his husband David Furnish, Baroness Doreen Lawrence, former Liberal Democrat MP Sir Simon Hughes, and actors Sadie Frost and Liz Hurley. Together, they allege that journalists and private investigators working on behalf of the newspaper group engaged in illegal practices such as phone hacking, blagging private records, and accessing confidential travel information. Associated Newspapers has categorically denied all wrongdoing. The company insists it did not engage in unlawful information gathering and is mounting a robust legal defense. What this sets up is not a celebrity grudge match. It is a courtroom clash about accountability, media, ethics, and whether powerful institutions can be held responsible for past practices. Within this context, Harry's witness statement offers something rare. A sober, detailed account of how press intrusion intersected with his personal relationships, especially with his brother. Harry describes the bond he shared with Prince William during the period covered by the claims. Because William was the future king, media interest in him was relentless, intense, and constant. And that pressure, Harry explains, naturally pushed the brothers closer together. As brothers, Harry wrote, we naturally discussed personal aspects of our lives as we trusted each other with highly sensitive information we shared about our private family and professional lives. These lines do not accuse William of anything. They do something far more revealing. They document trust. They establish that deeply personal information existed because the brothers relied on one another in an environment of extraordinary scrutiny. In legal terms, this helps explain why the alleged acquisition of that information would have been such a profound violation. And quietly, but powerfully, it challenges the popular narrative that Harry and William were always distant, cold, or adversarial. On the contrary, this is a portrait of two brothers shaped by the same institution, confiding in each other because survival demanded it. Princess Catherine's mention in the statement is striking for its simplicity. Harry refers to her only as HRH, the Princess of Wales, my brother's wife. No elaboration, no commentary, no personal detail. In a media ecosystem obsessed with reading subtext into every syllable, that brevity speaks volumes. This is not a memoir. It is not a podcast confessional. It is a legal document. And by keeping her reference concise, Harry avoids unnecessary interpretation while still ensuring the court record accurately reflects the family relationships relevant to the case. It is restraint, not shade. The statement also addresses Harry's relationship with his father, King Charles III, during the relevant period. Harry notes that they were in regular contact, and that voicemails left on the King's landline phone by Harry, other relatives and royal staff contained highly personal and sensitive information. This detail is critical. It highlights how vulnerable royal communications were during an era when landlines were still widely used and allegedly targeted by hackers. If those messages were accessed unlawfully, the implications extend far beyond gossip. They touch on safety. They touch on dignity. They touch on the basic right to private family life. What makes this especially poignant is the contrast between past and present. While King Charles recently returned to London for official engagements at Lancaster House, there were no arrangements for a meeting with Harry. No meeting with Prince William either. For observers, the contrast is striking. A witness statement recalling closeness and trust set against a present defined by distance and silence. But here's the key point. This case is not about reconciliation. It is not a public airing of grievances for its own sake. It is a legal action focused on alleged wrongdoing by a powerful media organisation. The personal only becomes public because of who Harry is and because courts require precision, not sentiment. The presence of claimants like Baroness Doreen Lawrence adds immense moral gravity to the proceedings. Her decades-long fight for justice following the murder of her son Stephen underscores that these allegations deserve serious examination. This is not about wounded pride. It is about whether phone hacking, blagging, and intrusive surveillance can ever be justified, especially when the victims include not just celebrities, but grieving families and private citizens. For Prince Harry, this case fits into a broader pattern. He has repeatedly framed his legal actions as a matter of principle, not vengeance. He has spoken openly about the toll media intrusion took on his mental health, his relationships, and his sense of safety. Naming his brother and sister-in-law is not an escalation, it is documentation. It records reality as it existed during the period in question. Courts deal in evidence, not optics. And while the optics fuel headlines, the substance remains unchanged. As the High Court hearings continue, the focus will remain on the allegations against associated newspapers and the evidence presented by the claimants. But beyond the legal arguments, this case stands as a stark reminder of the human cost of unchecked intrusion. It asks whether privacy still carries weight even for those born into the public eye. Prince Harry's decision to pursue this case and to speak plainly about the trust he once shared with his brother and father ensures those questions cannot be quietly dismissed.